Good afternoon, everyone. This is Payal Kumari, a third year BBA LLB student.
Good afternoon, everyone. I am Suraj Singh, a third year BBA student.
We
are
are the hosts for today's
today's
roundtable
roundtable discussion.
A warm welcome to all present here. Today's roundtable discussion brings together experts working at the intersection of AI, law, and judicial systems. As AI continues to reshape governance and legal practice, this event aims to explore its opportunity, challenges, and the way forward for India's judiciary. We feel honored to host distinguished speakers who bring deep expertise across research, policy, analytics, and legal innovation. To begin this session, I invite our keynote speaker, Mr. Shubham Kumar. Mr. Shubham Kumar is Consultant Research, Center for Research and Planning, Supreme Court of India, and a contributor to the White Paper on Artificial Intelligence and Judiciary. He holds degrees from RMLNLU and University of Windsor LLM Constitutional Law, has been a Lamb Fellow at PRS, a legal consultant at the Ministry of Law and Justice, and interned with Justice D.Y. Chandrachud. He has authored Unclogging the Docket and research on caste jurisprudence. We are honored to have him. Sir, the floor is yours.
Thank you. Thank you. A very good evening to all the participants. It's firstly, thank you, Dr. Navneet ji, for inviting me. And I would like to actually hear more from the panel because I am sure they have dealt with the issues of AI at a more in-depth level than we could actually do when we were researching, especially from the side of the Supreme Court. There are certain institutional obligations and certain embargoes also that we do have when we research for the Supreme Court. But yeah, the idea for this paper actually came when Justice Gawai, the former Chief Justice of India, he took over as the Chief Justice. And the common issue that we were also facing in our center and also in the submissions that we were reviewing. So the petitions that were being filed, a lot of them were using generic use of AI in drafting, at times also fetching the case laws. And the problem was that we do not have any specific guideline across any of the court. At least till that time, there were no guidelines by any courts across the country to how do we either regulate AI or we prohibit AI, or what should be the course of action. Because this was a common understanding that like it was in 90s, I guess, that people were unsure about how the computers are going to unfold. Later the internet came. So do we adjust, do we prohibit the use, do we regulate? And also the when we hear, especially from the legal field, the term algorithm, it directly takes us to the bias, so it flows one after another. So the idea was quite clear that we have to coexist. There cannot be a second view that we can do away with AI the way we haven't been able to do away with technology, and for the right reasons. It is there to increase the efficiency. So when we started with our research, the the point that guided us was to let's study as to what exists across the world. Initially, when we started our research, we did limit ourselves to the courts and the usage of AI across various courts in the world. And during our research, we did find, of course, there has been since 2023, during the tenure of Justice D.Y. Chandrachud, multiple AI tools were integrated in the Supreme Court itself. Like the AI was being used for transcription of constitution bench decisions. AI is being used right now in Supreme Court on a pilot basis for reviewing the defects during for the files that has been electronically filed. Apart from this, there is an AI tool that is not being used at a like at a larger level, but it exists, which helps in summarizing the case files, uh, highlighting, preparing list of dates, and assisting the judges in whatever manner. Like not that it's going to replace the decision making process, but just to assist and making certain routine and procedural tasks easier. At the same time, the AI is being tested at the case management level. If there isn't at any level at case management, we can integrate AI. So probably the listing of cases or the pendency can be addressed using the AI. However, these are plans which will unfold in future, and some of them are already, like almost all of them are already in public notice. They will be, I think, launched fully with a greater depth and detail after a lot of research and testing. But when we look at the artificial intelligence that has been integrated in courtrooms across the world, one common issue that we found was regarding the policy that exists. Now, the policies across the world, they are very generic in nature, so it prohibits the use of the unethical use of AI without defining what the unethical use would comprise. So this is what was also in our mind when we were drafting the paper, that we have to at least have certain suggestive instances, certain suggestive guidelines, that these are the areas where it can be used, and these are the areas where it should never be used. uh, for example, the AI, unless it's a in-house mechanism, so if Supreme Court or say any court, they cannot rely on a Chat GPT or a Gemini or any private AI tool. The reason being that the servers, the storage of data does not rest with the government of India or the courts. It can be used, it can be misused. So the first suggestion that we had after our research was to build a in-house AI team, AI tool, which would serve whatever purpose. Either if it's for research, it should be for that. If it's for detection of defects in the e-filing, it should be for that. But it has to be in-house built. The second suggestion that we did point out in our paper was to have an AI ethics committee. One thing that I have seen also from my experience, that a lot of committees that are part of the legal profession, judicial committees, or even the committees of the associations in the bar council or the bar associations, all of them invariably have lawyers who may have some expertise or some knowledge of say AI or say gender justice or say caste discrimination or even for trans rights or accessibility in it. We do have a bias of not involving experts and considering ourselves as one. So one of the suggestions that this paper has, that the committee should have judicial member, but it should have technical members also, because the exact contours of any tech can be vaguely understood by law researchers or even law legal academicians, but you need to have people who know the functional and technical aspects of AI, because whatever we are talking, probably we are talking of an AI, or whatever system we are using a system that was probably developed a year or two before, and after a lot of testing it is now being used. So we do not exactly understand the depth of AI that probably may unfold after 2 or 3 years, which may be at testing stage right now. And for that we do need people who are domain experts. Another suggestion that we came up was that it should not be used for any sensitive information, say in cases like POXO, where the sexual abuse of a children is being adjudicated by courts, or in any sensitive matter where the identity of the person, the instance, if at all it's compromised, may lead to severe consequences. So it should be used only for very specific, and it can be used in commercial cases wherein the files are voluminous in nature. There is a lot of calculations that are involved there. So in those instances it can be used, however with institutional safeguard, because judges, even though with all the knowledge, they need assistance when it comes to say if a matter has been pending for 20-25 years, it and there are hundreds of counter claims. It is a very tedious and very difficult task to ascertain what may exactly be. In fact, there are cases where we have observed that the lawyers, they file clarification that this amount has not been calculated properly in the order, then again an order is issued correcting the same. So in those areas it can be used. Other suggestion that we had was, whenever a law researcher or a lawyer, or even the at the level of the registry, if AI is being used, it should categorically be mentioned that this is the AI tool that has been used. These were the prompts that we have used to generate the content. In fact, this practice, is being used across like the academic institutions, say Oxford, Cambridge. They have come up with their suggestive use of AI in academia, where if a student is using the AI, it's mandatory for them to disclose also the prompt that is being used, to ensure that there is fairness, and to what extent the output is generative, and to what extent the output is just a paraphrasing of a content that already exists. This talks about the disclosure requirement. And then in the end part of our paper, there is a exhaustive set of suggestions or guidelines that we have laid down for in-house use of AI for the law researchers, and also for the lawyers, because that does not per se fall within the domain of the courts. And one other major issue that we found when the AI was like the AI being used across other countries, was that we need to integrate various tools. Now the problem is that we have 6 to 7 AI tools across like major AI tools that are being used by courts in India. AI Saransh, then there is Adalat AI, then there is Suas, there is Supace, there is Legra. So these are different AI tools that are being used by AI by the courts in India. If possible, if it is possible to integrate, or probably have one institution which will have repository of the data that is being fed into the servers, the outcome the output that is coming out from there, it would help in institution, uh, say so the machine learning, it will help in the machine learning, and it will ultimately help the institution in build a more robust AI framework. Because gradually, if at all we do want to experiment with the predictive AI in judiciary, which after our research we did found that almost majority of the country, they have discarded and they are not using AI in predictive analysis, because it has a lot of layers, and the human element is indispensable in judicial decision making. So they have done away with that. But if at all we ever evolve, or we come up with an AI which is that say like of that nature, then in such situation we would need a larger set of data. That will only be possible if we integrate the existing AI tools under one aegis. Say for example, now we have the open AI, under which we have different other AI tools like chat GPT, and then like various other tools that have been developed under the open AI system. So these were some of the larger suggestions. However, there are certain key say sort of suggestions that we could not mention, because they would fall within the domain of say legislatures or the policy experts. One of them being that despite the AI being used almost everywhere, we do have suggestive guidelines, we do have institutional notes, we do have certain rules, but we do not have anything about AI being mentioned in any of the legislations. So the IT Act, of course, it was amended quite a few years ago. The Data Protection Act does not mention it. So where do we fit the concerns that are being raised by AI or the uses of AI within the existing legislative mechanism? That is not clear. Probably an answer could be that we do need to have some guideline from the side of the government, and it should be in the form of incorporation in the act itself to make it more authoritative, because the guidelines are only suggestive even for the institution who is coming up with it. There is no accountability per se unless you have it in the act. You will have to have the law enforcement agencies also to be involved in the larger context when we think about the privacy violations that may happen because of, say, a law researcher or even a legal associate putting the sensitive document in an AI platform so as to ease the burden of churning out or summarizing a document overnight. They may do it very well, but what will be the consequences? The consequences cannot just be limited to someone's termination and then someone probably getting scolded. It should be thought from a larger institutional perspective. And I think the courts in India, at least when it comes to integration of technology, has been quite open. There has been various phases of e-courts, of which we are currently in the third phase of the e-court, and in which a significant amount of funding as well as emphasis is being put on AI. And because the pendency is mounting to such level, I think this has become one of the focus, that how do we, the question is constantly being asked, that how do we integrate AI? How do we integrate AI? There are platforms which already exist in public domain. One of our also suggestion was that the National Judicial Data Grid, which is the repository of, or the dashboard of the case status across the country, and it's a real time, almost a real time dashboard. It reflects daily pendency statistics. Now, if at all there is a possibility of integrating the data on National Judicial Data Grid with an artificial intelligence to also give a real time analysis report, if it is possible, then this can also be done. So this is also one of the areas where the AI can be used. Use of AI in case management can be done, because the listing now, even though across most of the courts in India, it's automated. However, automation should not just be based on a random algorithm that one case we will cyclically list cases after 3 months or 4 months. There are certain cases which needs to be listed faster. There are certain cases which may need more time to do the compliance, so they can be listed after 6 months also. So this, if we evolve a sophisticated AI tool and integrate that with the case management, probably this may also have a larger benefit in terms of reducing the pendency, finding out certain categories of cases which may be disposed of within one hearing. Like today, we are having lok adalats across the country. Now, a lot of cases in lok adalats should actually not go to adalats, should go to courts. Now, if at all there is a mechanism in which all such cases can be identified and listed before the lok adalat, because even in lok adalats, a lot of these cases get missed out, and then they are routinely listed before the courts. So if a cause list of such cases can be generated by the AI, or probably through the use of algorithm, this would ease the burden to a great extent, and maybe we can have more such interventions. As and when the tools are tested, the faults are highlighted, and then again they are reworked and presented. I think it's a great uh, sort of decision or institutional activity that the courts in India are taking, that instead of shying away from its use and questioning that it will hamper the process of justice, it is being gradually integrated. However, one thing that is per se clear from all the judiciaries that we studied, that the decision making is ultimately not being touched, and it will always rest with judges. The AI should be at every level to ease the burden, to complement the process of justice, and it should start from the very first. Like when we think of the legal profession, it should start from the time when a person thinks of approaching the court. Right now, the AI in the legal profession is when we have decided to file a case. So the first thing is when we go to the counter to file the case, that is where we find the artificial intelligence right now. But what if, as a client, as a person, I am typing something on chat GPT? So I did try one of the instances looking for a solution, and it was a problem related to Muslim law. It did give me an answer. It gave me an answer as per the Hindu Marriage Act, saying that the Islam Marriage Act or Shariat Marriage Act, it had like an answer, and there's nothing like that that exists. So it is learning from an existing tool and giving an answer which sounds very convincing, but it's not. Now, if I was a client, I would have gone to my lawyer saying that, okay, you do so and so as per this Shariat Act or the Islam Marriage Act, and it would just baffle me as a lawyer. So we need to also have an AI tool which sort of is suggestive in a way to give a roadmap to the litigants. After that, we go and file a case. So at e-filing stage, there is the integration of AI. Then we progress further. The case gets listed using the integration of AI at the case management level. Now the case file has been prepared. The lawyers may draft their submissions with the necessary safeguards. Then the argument is done. The research should also be done with a proper safeguard mechanism. The verification should be done for every content that is being generated through AI. Now, once it goes to a judge's chamber, the same responsibility vests with the researchers who are assisting the judges. And once the judgment has come, so during the hearing, the transcription is being done really well. It's almost as efficient as a transcriber would do personally. And then when the judgment comes up, there is already AI tool being used
Shubham sir,
to translate. Yeah.
Shubham sir, actually, we are running out of time.
Yeah.
So,
So yeah, I was
no,
just concluding. So this is where I think we see we have tools at our disposal. The safeguards are there. Instead of fearing its use, I think we should just think of how do we make it a more foolproof system to aid the justice dispensation mechanism. So yeah, thank you. I look forward to hearing.
Thank you so much, sir, for sharing your thoughts in such a different and insightful way. Next, I want to invite Ms. Smita Mutt to share her perspectives. Ms. Smita Mutt is a strategic initiatives lead at Daksh with a background in a political science and public policy, University of Chicago, MPP, NLSIU, and an ongoing global MBA. She leads data-driven reforms on judicial efficiency and institutional accountability. Ma'am, welcome.
Thank you so much, Suraj, Payal, and Vijay Bhumi Law School for having us today, University for having us today. So I'm from Daksh, which is a Bangalore-based research organization which works on judicial reforms and access to justice. At the first, I wanted to say that this particular white paper is a great step that is very much needed. It's very thorough and detailed and has had a very positive reception so far. There was a 2024 UNESCO study that observed that 44% of what they call judicial operators around the world, so judges, court staff, anyone working in a court environment, had responded to a survey saying that they were using AI in some way or the other. And so some of the courts had some guidance or some regulation as to how and where it should be used. And in many others, what was happening was what is called shadow use. So shadow use is where, say, for example, as students, You might use AI on an assignment without the approval or telling the teacher in charge of a class that there's a particular way you're using it. And it's the same thing that's being done in workplaces where employees might be using AI, especially generative AI, online free tools to simplify or streamline their work without the awareness or the approval of their supervisors and their bosses. So when it comes to courts, of course, this is a massive, massive problem. I'm going to start by talking about how one way that a lot of the literature talks about the different uses or the ways that AI tools are being created, it speaks from a functional perspective. So here is a particular AI system or a particular tool that's available that does transcription, that does translation, that does kind of a video generation of some particular kind. But when we think from more of a judicial administrative point of view, it's very important not to think of transcription as a single use case, but to think of it embedded in the particular courtroom, the particular case type, whether it's a deposition or a live courtroom hearing, what's the next step, and what different kinds of actors might expect from a transcript that's being generated. So, in general, the judiciary has been seen as a high risk area for the use of AI, in particular under the EU AI Act, which is one of the largest and only really large scale regulations or laws as to how AI should even be thought about within different sectors, and especially the public sector. But I think it's hard to think of the judiciary as a single, right? The courts in general as a single type of an area, and actually being able to think of whether and thinking of limited bans, if not an entire ban. So as Shubhamji mentioned, POXO cases, any place where there's a great deal of personal, sensitive, maybe medical information or information relating to minors. That's a part of the courtroom record. Those are areas where any kind of pilot or testing of a new AI system should absolutely not be done. And any thinking as to how it should be deployed should also take into account feedback and consultations with the entire ecosystem. Because when you think of a lot of family law or a lot of these more sensitive areas of law, you will not only have lawyers and parties and judges, but you will have social workers, you will have counselors, you will have a great deal of expertise that's very human embedded. That is a part of how those cases work and what justice really means in those contexts. So to this as well, I think thinking in terms of processes themselves, the workflows as the more corporate side thinks of it, and specific pain points that are felt by different actors. This is very important. I think Shubhamji mentioned the assistive function or things that are being recommended and not just decisions being taken on their own. I think one very important thing to add there as well is where or any place where subjective interpretation is being done is also somewhere where there should be a little bit of a care and a caution that's being taken. For example, there's a difference between summarization where one is extracting dates, costs, names, objective information that can be very easily verified by someone, versus where there's some degree of interpretation that's going on even in generating a synthesis or a summary. And so there, where some critical information could be in, say, the paragraph above or the paragraph below, that loss of the context of an original document will affect the fidelity or the accuracy of the summary that's being generated. And so given that all inputs into judicial decisions are so very important, we don't think of judicial decision making as a very black letter or as a very literal exercise. Oftentimes it's that context itself, it's the human subjective judgment that is being considered very valuable. So to be able to separate, I think, those kinds of processes, places where we think that discretion and subjectivity are valuable versus those where it's very important to bring in more predictability or clarity. So, for example, there are places where some degree of discretion, especially in administrative tasks, can potentially open the door to some kinds of that discretion can kind of go in a direction that's where objectivity would be preferred to a greater degree. So I think the final thing that I'll come to before wrapping up my comments on this as well is the white paper includes some fantastic safeguards as well. They've talked about the need for having the human in the loop, for having an actual oversight and verification, especially with things like translation of judgments or other documents, where it's important to have clear disclosure as to what kind of AI is being used and how that is being used and what kind of AI is being used, and making that very clear to lawyers and parties themselves, as well as putting in putting in safeguards that can try to prevent bias at large. Something to think about is just that the institutional readiness of courts themselves, it includes very important questions about hardware, about internet access, things that are there to some degree in some high courts, definitely there in the Supreme Court. But across the district courts of India, that's not something that can be taken for granted. And so that will require a great deal of preparation, of preparing the ground for any kind of broad use of AI. In addition, it's important to have clear policies to govern the handling of sensitive data or any kind of public or non-public data that is being handed over to third parties, shared with third parties who are building some of these tools for the courts. It's very important to involve kind of to involve third parties, whether they're public universities or private developers, in building these systems, because there's already so much that we're asking our judges to become experts in, additional to the main work that they may have. And then here as well, I think very important safeguard to add is the possibility of grievance redress. It may not be possible in advance to think of everything that might go wrong. So if there is something that a lawyer would want to kind of bring to the attention of the court, that because AI was used in this particular way, this kind of a decision might have been taken, even if there was a human layer on top of it, this is something that should be addressed and mitigated and planned for in the future. Having some kind of clarity on that and having some kind of a clear way to address those harms is very important in the long run. And the final point that I'll just make is it can be hard to bring in long-term judicial reforms with the frequency of judicial transfers. So currently, when we think about the way that courts are looking at AI, every time the high courts are kind of cross-learning from each other, taking huge steps in this way, and the Supreme Court is absolutely doing this as well. But whenever there is a change in the decision maker, the key decision makers, perhaps the Chief Justice, perhaps the heads of computer committees or IT committees, that can serve to be a huge interruption in any planning. So it's very important to have a way for these plans to be multi-year, long-term, and not be extremely dependent on who is in charge at one point in time. So there's a way for that to be built on going into the future. So these are just some points. As Shubhamji mentioned, I think there are a large number of points that can be made because this is such a evolving field. But one thing I will say is while AI is a very, very new technology in the way we are looking at it and thinking about it now, many of the institutional problems that exist are true for data and are true for technology more broadly. So they have not come in only now with, the last 3 years that ChatGPT has really come in and become so prevalent. These are things when it comes to having digital infrastructure in the courts, in terms of training and in terms of kind of moving ahead. These are things that can affect judicial processes more broadly. So I will end here. Thank you so much for this opportunity to speak today.
Thank you, ma'am, for offering your thoughts in a way that encourage us to think differently. Our next speaker is Dr. Chandrasekhar Subramaniam. Dr. Chandrasekhar Subramaniam is a senior professor of analytics at JAXOM with expertise in text mining, sentiment analysis, and applied analytics. He brings deep experience in IT and quantitative techniques useful for discussing AI, data, and evaluation framework. Sir, over to you.
Good evening to all. All of you are able to listen?
Yes, sir.
Yes, sir, we can.
Okay. It makes my life little simpler. I thought she will ask me to speak in the end so that it simplifies my work. Whatever I wanted to say, most of you would have told. But anyway, somewhere I am the midpoint. My experience, I will tell you, one of our IFIM students who passed out in 1998, I think, Snehanshu, he worked with NASCOM. He was heading the AI/ML division of NASCOM. And he left NASCOM, and one day he came to me and said, "Sir, I have left the company, got bored. What do I do?" So I told him, see, this legal community is one community where the volume of data is very large compared to others. Their volume is so high. I don't know, it is tough to compare with retail or telecom or anything. They have huge data. So why don't we take this field up, because Gen AI is trying to start now. A startup was also formed in which I became one of the advisors. And he was looking after that. So what we did was we hired I think about 10 students from RV Law College and another 5 senior 5th year students, and some faculty were also involved. So what we did was, I think one of the speakers raised that I give a command to chat GPT instead of Sharia law, it gave some, yes, it will definitely give. What has happened is none of those back-end LLMs, whether you take ChatGPT or Gemini or Mistral or Google, they are not trained on my Indian legal data at all. You will have to keep it in mind. Definitely it will happen, there is no doubt. So the best thing for our country is we have to build our own foundation model. Please don't simply put a query to this and expect some good answer to come. No, it will not come. See, when the machine itself is not trained on my country data, how can you expect it to give an answer? It will not. So what we did was we started developing a foundation model for our own country, because we thought when the knowledge there is not useful for me, what is the point in taking that knowledge? It doesn't lead to nowhere. So what we did was we took that small 32 GB model. There is something called retrieval augmented generation. So we used, I think, that Manupatra database. If I recall, Kanun.com is there, Manupatra is there. So our own country data we trained using, and there were some 5 or 6 computer science students also. They came from RV Institute and PES College, I think. These two are supposed to be known to produce some good computer science BTech students. So finally we trained the machine and showed it to few lawyers also. But somehow, let me tell my experience. Long back, you remember when the banking software was introduced, those class 3 and class 4 employees fought tooth and nail. They said, sir, we are all becoming displaced, we will all becoming jobless, we do not allow these computers to come. Same thing we are facing here. Somewhere at the back of the mind, I think you have to pardon me, this legal community thinks their revenue will come down. That is where the whole problem is. So the writ petition, it will generate in some few seconds or few minutes, whereas you take 1 hour and ask the client to come next day. The charge will drastically come down. As you said, I definitely agree. You have to treat this AI as an intern in law. Don't treat them as some legal expert. It is always like an intern. You treat it like an intern. So whatever the output it gives, it has to be validated by a senior lawyer. No, it's not that. That's why I said I compare to an intern. Intern, he or she is very much enthusiastic to show some results in a very short time. So without looking into 2-minute dimensions, they will bring something to the table. So the thing is, anyway, senior is there, let them also do some work. Probably that also may be there. That is how I will learn. If I do everything, what do they do? So probably I think that is how they look at it. So you please treat it as an intern. And what happened after the computer came, most of the jobs did not go. Today, you go to a bank and let the server fail for 10 minutes. Ask him to make a DD. He will cry. He will say, sir, I don't know what to do. Server is down. You come after half an hour. He is unable to do a DD, whereas the same community fought tooth and nail. They said, we do not want computerization in the banks. So what happens is, it is something like an Excel. When Excel was introduced, most of these accountants thought all of our job will go off. It will do all addition, calculation, multiplication. There are n number of functions in Excel. It will do what happened? No, nothing. No, nobody got displaced. What happens is they started doing a little bit higher level job, leaving this monotonous job to the machine. That is how it has to be looked at. See, let that, what you call boring type of work or repetitive type of work you transfer to the machine. The knowledge part you keep, and simultaneously you train this machine. That is how it works. And the second, I think, lesson all of us have to learn, there is a legal community, many of them are there. This software cannot be developed only by the legal community. See, what happens when you take that large language model, there are a lot of parameters that has to be tuned to your specific data. If I take retail data, I will tune it in one way. You take our telecom data, we train it another way. You take Facebook data. So now what happens is, after all, I think this whole machine is mathematics. It doesn't know text. Eventually, inside the machine, we translate to numbers. That is the whole theory. Now there are some 10-9 parameters. You give whole type of text. there is something called embedding that happens. So if you do a wrong embedding, your query will go haywire. So the first question that has to be done is whether we should embed it at the sentence level, paragraph level, document level. These are all technical things. So unless you involve a technical expert plus domain expert, if this software or anything is developed, no, it will not work for you. No, it is very clear. You will get accuracy of only 40% or 45%. It will not give you what is expected. That is the first part. There is something called random. There are something like 14, 15 parameters. In any large language model you take which runs at the back end, the query you give it in the front end, but at the back end we run something else. It can be chat GPT, Mistral, whatever it is. These are the parameters that has to be fine-tuned. So for legal community, what happens, since you are the end experts, you are the better persons to give. And one of you said, yes, human in the loop, yes, that will happen. Now what will happen, let us say this chat GPT gives 1 page of output. Now as a legal expert, you will say, sir, these first 3 lines are useless, delete. Delete, I don't want it in the output. You will add some another 3-4 lines, the machine has to be retrained. Because if you give a query, you will get the same answer. It will not give you the new answer. This is what we call the fine-tuning of the machine. So second time I will train it in such a way such that it will give close to your expected answer. Otherwise, no, it will not come. Simply putting a chat and trying to play around with that, what you call the query, trying to refresh. No. You will not get the same answer. The machine has to be retrained. For retraining, you need a technical person. So our experience, I think, to the legal community is, unless both of us will join, this good product will not come. You will always have a problem if you simply use a query and then send it to the backend. Then what happens is we will have to put some guardrails at the backend. Just one sentence I will speak or I will speak. So unwanted knowledge, if it takes from the backend, I will have to filter it. These are called the guardrails. This is something technical. A technical person will be able to put it. So that the junk knowledge from the backend will not come and override the good knowledge we took it from the local machine. So my experience is, I think both the communities have to join. And I think finally, if some lawyer doesn't use the GPT, that lawyer who uses the GPT will replace them. That is what will happen finally in 2 years. Lot of these foreign companies are coming, they will force you to do it. I think with that I will conclude. Might give a chance to others to speak.
Thank you, sir. Your unique approach and insights added a great value to our understanding. So our final speaker is Advocate Shashank Sharma. Advocate Shashank Sharma specializes in competition law, economic analysis of law. He has worked on platform regulation, big market studies, and has academic experience including NLSIU. Sir, please share your thoughts.
Hi, everyone. So first of all, Dr. Subramaniam, I understand that lawyers have a phobia of mathematics and everybody has a phobia of lawyers. So it's a bit of a bad combination there. But, I went through the paper, so I don't have much to add because a lot of the ground has been covered already. But a few thoughts, because I'm also working on a project where we are looking at a specific regulator and how we can use perhaps AI tool to assist them in fine-tuning their internal procedures as well as order writing procedures. But be that as it may, coming to the white paper and certain, I don't have any critical comments. I just have some suggestions, perhaps. So one thing you could consider, because anytime you try to impose a new project, so to say, because what we are looking at is a slow accretion of AI systems into the judicial processes of the Indian state, you will need to manage the certain various states in which you introduce them. So one way could be to look at, we talked about pilot programs, but perhaps a good site to begin would be the tribunals, the umpteen tribunals that we have in this country, right? Because you're also usually in the tribunals, you're not also dealing with personal liberty issues typically. So if you want to say the stakes are relatively, I shouldn't say low, but relatively low compared to a high wire act at the Supreme Court where personal liberty is at stake. One more thing which I would say is, which would be important is to, whenever we introduce a new system, we need to be sure, just because everybody says AI, we also need to test the proposition that it actually does bring some value, right? So that's sort of the crux of the scientific method in some senses, right? So what you might do in the next 2 year period or a 3 year period or any medium period to introduce sort of a, I'm using the term shadow docket in a different way. Essentially, you continue in parallel with the decision making processes as they happen at, let's say, the Supreme Court. But you also introduce a parallel regime where the same cases are tracked by a team, or some sampling of cases is tracked by a team which actually decides, works on those cases within an AI system. So essentially, you're working in a sandbox. You're not affecting live case judgments,
Correct.
but you will see what problems are there. First and secondly, are your decisions which are coming out with the use of AI assistance, are they actually converging with the decision making of the judges or not? If there is a great deal of divergence, then it's an interesting finding either ways, right? Either our judges are not being good or our AI is not being good, right? So it's an interesting finding either ways. Uh, one finally, in terms of how to deal with hallucinations. Now, obviously, the technical problem is very difficult to solve. That's there, but there are certain, how do I say, the low hanging hallucination problem you can solve to a certain extent by personnel. If you have cross validation panels within the Supreme Court, let's say, right? If there is a team of interns which is working on a case, you assign another team in parallel which also works on the same case, and you can cross validate that data, your findings. So what that can do is it can give you a certain sense of, essentially, you're solving by game theory what you could have solved by technical by some computer technical skills. One final thing which I would say is this is all the present and the future. In fact, I think something might be very interesting is that a problem with the Indian judicial system is the lack of granular data, especially backward looking data. We have had a situation when courts in the last 10, 15 years have started to look at the data availability itself as a problem. So you have more digitization and you have more and more data being present. But if there was a corpus of data which is machine readable, machine analyzable it properly, you could also deploy AI in it to find patterns which might actually help you with the administration of justice going forward. So I'll give you an example, a slightly contentious example, but let's put it this way. People say that in India senior advocates charge a premium because they're perceived by the bench in a certain way. One simple hypothetical, and this is literally just a hypothetical which I just made up right now, would be: does the presence of a senior advocate, ceteris paribus, controlling for everything else, lead to the passing of interim orders in the favor of the defendant partner? Right? You could have some sort of a testing of hypothesis, which could give you insights which you might not have. But that is more of a question of a creation of a corpus which is friendly to AI based analysis. One final point I would make is, now my experience with the Supreme Court is not that extensive, but I think as in the paper, Shubham, you point out, the removal of defects is a challenge in itself. Usually a filing entails a week or 2 or 3 of back and forth with the court registry and trying to remove defects. I think some of that could also be, and I think it is increasingly being solved by just tailoring the submission formats in a manner that they are difficult to gain. If you make the submission formats somewhat logical, somewhat in the shape of a logic tree, if you want to call it that, and if it is, a tick the box is not going to work because there are access to justice issues also, everybody should be able to approach the court. But to a certain extent, if the submission formats were so that they are also more easily analyzable by human or AI, that might be something which is useful. And one thing which I would say was, I think I started with this is, Shubham, I think you pointed about that you wanted the government of India to perhaps talk about the AI policy when it comes to the courts or the legal systems. See, there I'm wary that the Supreme Court is very jealous of his turf. So, and in fact, it's also a matter of domain expertise, right? If the administration of justice is in the realm of the court, in the Supreme Court being sort of the parent patry of the entire Indian legal system, it could be perhaps easier and better if it just started this policy making mechanism, or the guidelines actually came from the Supreme Court itself. So that would be my final point. And I think, there's a lovely paper to read through. It is. Thanks.
Thank you to all our speakers. We will now open the floor for questions. Students and faculty, please raise your hand or state your name and questions briefly. Are there any questions anybody needs to ask from students or faculty? Kindly raise your hand and ask.
In the meantime, let me invite my colleagues from the tech school and the law school. Dr. Saurabh, I can see Dr. Saurabh Kumar is here, and my colleague Nitish is also here. So why don't you guys, while we are still waiting for questions, would you like to make some brief remarks on the deliberation so far? Because these are people who are actually doing a lot of real stuff inside the schools. So I think it will be very useful to hear from them.
Right. Hi, Professor Navneet. Hi, this is Tejas Karta from the tech school. I'm sorry I can't turn on my camera right now, but because I'm traveling. But I was listening to the entire conversation. I was in for the entire webinar. And I really like the points brought up by the panelists that we have today. Especially, I was listening to the points brought up by Professor Chandrasekhar. His that important point where he mentioned, a large language model, having this capability of extracting knowledge, which is probably not so relevant to the conversation and the context actually not being always fulfilled in conversations. So I think that's a very important point. And I've always been personally making that point to most of my students and other, yes. So that I think is an extremely important point. That is one comment which I wanted to make, because being users of AI or tools of AI, we should always be aware that this problem is persistent unless and until you have very specific cases like retrieval augmented generation or otherwise. Yes.
Thanks, Tejas.
And one more line I can speak. Originally, when the LLMs came, almost most of the data has to go to the cloud. You will have to go there. Now,
Right.
with the advancement in these GPUs and other things, and what we call that training the small language model, adding some additional knowledge layers.
Right.
On a normal server itself, it will run. So I think maybe in another 6-7 months, you don't have to send all the data to the cloud. It will remain there. It will remain in your own office. That is how the technology has come. I attended 15 days back. We have that Bangalore Technology Summit. And a single card, 4 GPUs have come. That is much more enough. So what you do is you simply put an additional card to your local server. I think almost 70 to 80% of our query we should be handled in-house only. It will not go to the cloud. I think that is one of the hesitations most of the lawyers have, that our clients' confidentiality has to be kept. So they are a little bit scared what type of security will come in place if the data moves to the cloud. I think in another 6 months, no, you just put a GPU card on your own server, it will work. And even on a laptop with that 32 GB model trained, most of the queries like writ petition generation, contract, raising the red flags and all, it will do locally itself. It will not go to the cloud.
That's very valuable. There was one point, Shubham, I was wondering, the language part, because given the linguistic diversity, I was thinking that you would cover the usage of Bhashini and bridges across Indian languages in the judicial work. That was one thing I was hoping that you would cover somewhere. But I think Professor Nitish Kumar and Dr. Saurabh Kumar, they are waiting.
Let me answer that one. We have that Sarvam.ai which will work in 22 Indian languages, including spoken language. It has a voice-to-text translation also. They have done it. They have got 200 crores funding recently from the Ministry of IT. It works. We don't translate to English. Then it goes off. You cannot translate to English and then English to the... No. They are not doing it. They are training using local corpus on the Indian machine. That should go to the judiciary also. They are doing it.
That's right, sir.
It has been done. Again, IIT Chennai, another MBA from Ahmedabad, and somebody from, I think, one of the law schools from US. He has come back to the country and then done it. It will be available. Another 1 month, they are thoroughly testing it.
It's so great. Good to listen, sir. Yes, Dr. Kumar.
Yeah, thank you, sir. So I think it was a very good discussion, and we got some really good points that how do we actually integrate AI to the Indian judiciary system, right? So one of the most important things that we need to understand about AI is that nowadays, when you're doing ChatGPT or anything, people are taking it to face value, right? So whatever you get in the output of ChatGPT, it's not always true. There is always a need to cross check. So as clearly mentioned by Chandrasekhar sir, that when you get something out, you have to use it as an intern, right? You always need a supervisor who will look out for the mistakes that any LLM is making. Second thing I want to point out is that an LLM which is trained on the foreign data or external data will not work in for the Indian judiciary, because our systems are different, our data is different. Right, so we need to have an LLM which is trained solely on the Indian data, and it has to be specific. So it's not like a universal LLM which can solve any type of problem.
No,
it has to be specific to our Indian judiciary only. So it will only solve, or it will only answer questions related to the judicial system. Third thing that I want to point out is that any artificial intelligence model is not very accurate about the outliers. So whenever you get some exceptional cases, like for example the POSCO Act or the TADA Act or different kinds of, right? So AI is always trying to looking for patterns which have been repeated over and over again.
Correct.
So in case you get exceptional cases which are not general, in that case AI will not be helpful to you. When you're doing research, it will give you wrong information, right? And it will also try to distract you from what you should be asking. It will try to give you wrong answers because its job is to give you answers. So in that case, the chances of hallucinations are very high. So these are the things that we need to keep in mind when we are trying to incorporate an LLM or AI into the Indian judiciary.
I can quickly show you before Dr. Kumar comes in. Do LLMs bullshit? There's a recent paper which says yes.
Yeah.
But with that, let me get Dr. Nitesh Kumar here.
But Navneet sir, if I may, so do lawyers.
Yeah, please.
But
please.
Very true.
Sorry, everyone. I'm running short of time and I need to step out now. So I just wanted to say thanks for inviting me to this. It was a very pleasant conversation between all of us, and I look forward to further iterations of your work, Saurabh, and the Supreme Court research cell. I now need to take everyone's leave. Thanks.
Thanks for joining us. Yeah, Nitesh.
Yeah. Good afternoon, everyone. And it was pleasure listening to all of the dignitaries over here. I'm heading to law school here, and I have few basic points. I think we have Ms. Mutt, and of course Mr. Kumar also talked about it. Mr. Sharma also talked about it. I want to put some emphasis about as a lawyer, we all deal specifically in jurisprudence. We have law and morality that comes in. So, as a lawyer, when I see AI stepping in as a bigger help, of course it does. But what I feel as a bigger challenge is, how do we train AI to understand ethics, morality, and over that, like for example, all of us we know black box, defect regarding the transparency that has been rightly pointed out over and now and then again. So that's something that needs to be addressed, because this is something. Also, I think Chandrasekhar sir mentioned one very unique point that I would totally second to, which is regarding the foreign mechanism. If you talk about their LLM or their Gemini or stuff like that, they are trained in a different mechanism, and they are not adhered in the same way what we are up yet in India. Of course, in Indian legal system. How do we address that? I mean, that would be my concern, because of course, if you talk about when concluding my question, if you talk about judgments are, maybe even after 100 plus years from now, I believe it will be, maybe there will be some robot taking a judgment seat also. that can be possible in coming years. No wonder. But I believe the human minds have created AI, and it will not be replaceable. Some or the other way, we will align to philosophies again in some or the other era. So how do we train AI for a better efficacy of ethics? I mean, that would be my question. Anything.
It's really important point. And let's, in the meantime, before I invite Dr. Shubham Kumar to come back and provide his closing remarks, can we have a fresh round of questions? Anybody who is participating and have an observation or a quick question, we can take, and then I will request Dr. Shubham Kumar to give his closing remarks, because he is the one who is part of the drafting team of the paper. He has heard a variety of comments, including how much of process support, how much of substantive support, how much of predictive support, and how to train the Indian LLM, and etc. So, and since I don't see any hands up or any questions in the chat box.
One thing is, I think at least in the final year, even though you don't run too many courses, one or two electives should come for the legal profession also. What is this about, and what happens in the background when they give a query, so that they will not get unnecessarily carried away by what is this. That is the first part. The second part is you have to challenge the LLM. That means your own knowledge has to go up. See, there is a catch. See, when once it gives some wrong answer or something, unless you know more than that LLM, what do you challenge? You will simply accept it. So both the profession, both the teachers, their level also has to go up now, because the student will use the chat GPT and he will bring it to you. So unless your knowledge also goes up, no, you will, as you said, you will blindly accept. So the teaching community also has to work more.
My response to that is, sir, on behalf of my colleagues Nitesh and Saurabh, let me assure you, Vijay Bhumi is going to be the first university to offer that course, sir.
Yes.
Let me assure you that, sir.
Yes.
Yes, Dr. Shubham Kumar, your closing remarks, and then we will close.
Yeah, really, like these comments were really insightful. I wish I had some greater power to incorporate these into in the legal profession. But I would just like have 2 to 3 very short response. Like one of them, I think Shashankji mentioned. So I was talking about a regulatory framework in general, so incorporated in the IT Act and the Data Protection Act regarding the use of AI and how it should be regulated, not just limited to the legal field. It should be for every field wherever the AI is being used. And the point that has been rightly mentioned, that we need to not just train the LLM, but we need to train ourselves more than the LLM, so that we can find where the LLM is going wrong. And insofar as the integration or usage is concerned, we will gradually find the areas where it can be integrated, the areas where it should be used with much more caution, the area where we can rely more on AI, and the area which Nitesh mentioned, like in the realm of morality or questions which are very tricky. I think the LLM is trained on something that exists. A lot of questions that come before the judge or the courts, these questions are completely new. A basic structured doctrine that was evolved by the courts did not exist earlier. So something like that probably AI would not be able to suggest, and that's why I think we will have some edge, at least when it comes to the training part, and also keeping our say sort of expertise still there after a point of time. But a great suggestion. I hope we can work something on it at a later stage, maybe a 2.0 of this white paper. So thanks a lot for the suggestions. It was great hearing Professor Navneet Sharma, Shashank ji, Smita ji, and Chandrasekhar sir. Thanks for the insights.
Thank you all very much. Thank you all very much.
Thank you, everyone, for your very energetic participation. Saurabh, would you like to propose a word of thanks? And then we formally close it?
Sure, sir, sure. So, thank you, everyone. Thank you for being here. First of all, I would like to thank Mr. Subham for joining us and giving us the insights about the paper and also informing us about what is the current status of integration of AI into the Indian judiciary. Then I would like to thank our experts, Mr. Shashank Sharma and Smita Mutt, who gave us the lawyer's perspective and about the integration of AI. Then lastly, thank you so much, Dr. Chandrasekhar, for accepting our invitation and giving us your insights about what exactly happens in the background of all these LLMs so that we can properly incorporate them into the Indian judiciary. Lastly, I would like to thank our organizers. First of all, the one who initiated all this, Professor Navneet Sharma.
No.
Then the conveners, Suraj and Payal.
Suraj.
Then our Marcom team, Vibha, Param, and Professor Nitesh. Thank you so much for joining. I think it was a very fruitful discussion, and I hope everyone got a lot of information from this discussion. Thank you so much.
Thank you all very much. Thank you.
Thanks a lot, everyone.
Thank you.